Okay. Ms. Sarkis, we're ready for you.
Okay, thank you. May it please the court, I'd like to reserve 5 minutes for rebuttal.
Okay.
We are here on appeal of an unlawful detainer action. That is a summary proceeding where the sole issue before the court is the right of possession. Here, the judgment grants Petros and Divine possession over 1207 and 1219 North Vine Street. And that judgment is based solely on the 2009 lease. But that lease on its face is for a different address, 1201 North Vine Street. The property description, yes, Justice Crandall?
This is kind of...
Start again. Couldn't hear you. Start again, please.
Okay, so one of the... I hear what you're saying, but wasn't it true and undoubtedly true that everybody understood that this was for the banquet hall adjacent to the church? And that's what this whole bargain was, whether it was oral or it was written. They weren't using it for the sanctuary, right?
So the diocese agreed under the terms of an oral lease that Divine could occupy the hall free of charge while Petros was acting as the benefactor for the church and paying for the ground lease. That's true. But once it came to the 30-day notice to quit, Divine came back and said the 2009 lease gives us a 30-year right to occupy these premises. And it was their burden to show that they had the right of possession under that lease. And that lease, as I said, on its face is for a different address, and it's unambiguous. Yes, Justice Bendix?
But can't there be extrinsic evidence admitted to show a latent ambiguity?
Only it's an objective standard, and it's a legal question for the court as to whether extrinsic evidence is admissible, and it's only admissible if the address language is reasonably susceptible to mean something other than it does. And
there was extrinsic evidence that from more than one witness, I believe, that said that they commonly used the church address in referring to the banquet hall and the church as an entity. And I think Judge Crandall correctly states that there was no question that no one intended to use the place where the banquet hall was operating out of, for a church or for any other function than the banquet hall for the church. So the intent of the parties was clear. So I'm having trouble with your argument that we stopped the analysis at well, it says, what's the address? 1501 North Vine or 1601. I can't remember.
1201. I know the number.
1201. Forgive me, North Vine. That's unambiguous. Close your books. Let's go home. You know, I don't think it's that simple.
But I think what you're really talking about is reformation of a lease, and that's not unlawful detainer.
No, I'm not. That's okay. Assuming. No, I'm not talking about that. I'm talking about ambiguity in interpreting the lease.
Right, and our
That's
position.
That's not reformation. I'm talking about interpreting it to begin with.
I understand the distinction that you're drawing. So our position is that extrinsic evidence is not available because 1201 North Vine is not reasonably susceptible to mean 1219 or 1207 North Vine. And so you don't look at extrinsic evidence because you don't get to that stage. Yes, Justice Kern.
Doesn't that lead to an absurd result? That we know what it is, everybody said what it is supposed to be used for, but it had the wrong address on there, so we all go home. And that doesn't seem fair. It seems absurd.
No, I disagree. I mean, the St. John and Divine's position is there was an oral lease and it was for that property. Divine comes back and says, I have a lease for a different property and that entitles me to occupy the hall for a 30-year term. And it is a technical argument, but it's an accurate one. And property rights are technical and unlawful detainer proceedings are as well. Yes, Justice Rothschild?
So is your position that you have the right to occupy 1201?
That Divine and Petros, that Divine has the right to occupy?
Yes.
I mean, I think that would be the outcome, yes. If we're accepting that the lease is valid, then yes.
Then you get to occupy the church?
That's right.
I just wondered if that was your position. But then, so you don't really, well, you're saying that's what the lease says, and so no, but you don't get, but on your interpretation, you do not, I'm sorry, hold on. I'm sorry, I have the parties mixed up a second.
Yeah, I think so.
Under your interpretation, then Divine gets to occupy 1201. That is the church.
That would be the outcome under this lease.
And so that's okay with your client. Never mind.
So
you get the banquet hall and they get the church.
Right.
Okay.
So I do think that this argument makes the appeal pretty simple, and that's particularly true as to Petros, who disavowed any right of possession over the hall, and his counsel stipulated to the same thing. And what Divine has argued is the trial court made a credibility determination that the lease applied to a different address. And I don't think that the trial court had the power to do that. And as I mentioned, it's a legal question as to whether extrinsic evidence is admissible, and here it's not. And I think what Divine's real argument here is that the lease applies to a different address, and that's what the parties meant, and that it was a mistake, and that the lease should be reformed. And that's something that Divine can take up in a separate action if it chooses, but that's not before the court here. And that's not an available remedy in an unlawful detainer. Yes, Justice Crandall.
So, but even if we bought your argument, there'd be the issue of equitable defenses, right? And the trial court didn't believe your client whatsoever, didn't believe anything that he said about the existence of an oral lease, and was very emphatic about that. So all we'd be doing is remanding, and then it would come back again as an equitable defense, and the lease would be enforced anyway. So aren't we wasting our time with this?
I don't agree, because I don't think that you can rewrite a contract by estoppel. And that also wasn't a basis for Divine's defense. And it's not reasonable to rely on a lease for a different address to give you the right to occupy 1207 and 1219 North Vine. And let's look at the true equities here. I mean, Divine was occupying a hall that has a market value of over $75,000 a month and paying $0 in rent while reaping millions of dollars in benefit. So I don't think the equities favor Divine.
But that's an action on the contract. I mean, if there's a lease violation, that's still an open question, but you were trying to boot him out on a summary proceeding, right? Right.
That's true. And there's also the question, so in terms of the trial court's equitable findings, what the trial court said was that the plaintiffs were stopped from saying that Father Makarian did not have actual or ostensible authority to sign the lease. And that's not what this appeal is about. Under the substantial evidence standard, we accept that is true. But the point is that Father Makarian never acted to bind the diocese. He only signed the contract on behalf of St. John. And it's undisputed on this record that the diocese is the sole owner of the banquet hall, and that St. John had no power to lease the premises.
Well, don't you run into issues of express authority per his signature and potentially ostensible authority? I don't think it's as cut and dried either on that point. Though it's an unfortunate situation when a trial court estate doesn't believe a clergyman, but that's what happened here.
Right, but for ostensible agency, it requires intentional conduct on the part of the principal that creates a belief in the minds of third persons that agency exists. And I think when Father Makarian signs a lease on behalf of St. John, yes, Justice Crandall?
So I just want to follow up on what you just said about not binding. So the executive director of the diocese said that any agreement that a parish commits to as part of the diocese, and our bylaws are as such. So doesn't that sort of cook the goose on your argument of apparent authority? I mean, the diocese is saying that, the executive director is saying that, yes, the priest could do it. And not only that, but he signed the lease on behalf of, I believe it was the parish. Didn't he?
I think that we would have a problem if Father Makarin actually acted to bind the diocese, but he didn't. And when he did sign documents on behalf of the diocese, such as when Divine was looking to get their liquor license, then he did so. He was a signature line where he was signing on behalf of the diocese. He didn't do that here.
He represents that he signed the lease as, quote, the owner or agent with authority to enter into this agreement. You're saying that has no value legally.
Right. St. John does not own the premises. It does not have the power to lease.
You still have a few minutes left before reserving your...
I'll reserve the remainder of my time unless you have other questions for me.
Okay. Thank you. Ms. Grignon?
Good afternoon, Your Honors. This is a pretty straightforward, substantial evidence appeal following a court trial. So we know that the trial court found that the Archbishop had no credibility, that he signed the two leases, and we know that the trial court found that the, Archpriest acted with actual and ostensible authority for both entities. Those were factual determinations that were made by the trial court, and there's no basis for the court to look behind those. With respect to the address, the court is correct. There was ample extrinsic evidence with respect to the 1201 address that encompassed the entire property, and that the Divine Catering used 1201 as that address when it was communicating with outside parties. So based on that, the 1201 address is the correct address for that property, and the lease was valid with respect to that. With respect to the actual and ostensible agency, in the reply brief, appellants concede that there is ostensible agency with respect to the church. And now, for the first time on appeal, they never made this argument in the trial court. For the first time on appeal, they say somehow that the church was not an owner of the building, and that it's undisputed that the diocese was the only owner of the building. Well, that's not raised and has been waived. But despite that, the church and the diocese were both master tenants for the lease of the land. They were both co-tenants for the lease of the building. They brought a joint unlawful detainer action with respect to the land and the building against my clients, and they said that they jointly entered into an oral lease agreement with my clients. So for this newly minted argument of now all of a sudden it's only the diocese that can enter into agreements is totally contradicted by their own actions. In addition, if you look at both the testimony and the documentary evidence, you will see that sometimes the church does something, sometimes the diocese does something. It's always Archpriest Makarin. Archpriest Makarin, sometimes he says, I'm doing this for the church, sometimes he says, I'm doing this for the diocese, but the zoning application and the liquor license was done under the auspices of the diocese. There are documents, for example, the building permit and certificate of occupancy, that was done under the auspices of the church. So sometimes he said he was the owner and agent. So he did not keep straight what parties he was operating for, but it's absolutely clear from the record that the property and the building, that the church and the diocese were co-tenants. And now, as the law, as we've pointed out in our briefing, a co-tenant can lease property for another co-tenant, and that second co-tenant is bound as long as it's getting benefits from the lease and doesn't object. And that's exactly what happened here. The diocese is getting benefits from the lease, and certainly has not objected. And it knows that for a decade, Divine Catering has been operating its business out of the banquet hall. Give me just one moment to make sure there's nothing else I want to add. Oh, and then, yes, and of course, the very important evidence, as Your Honor pointed out, with respect to the executive director, that the parish and the diocese are one and the same, that when the parish enters into agreement, the diocese enters into an agreement, and that's the way their bylaws operate. So I think it's crystal clear that not only is it not undisputed that the diocese owns the building, the evidence all goes the other way. Unless the court has some questions, I will submit.
No, there are no questions. Ms. Sarkis?
Sure, just a couple of minutes. In terms of the issue on latent ambiguity, I think the Beckett case is instructive. And that case says that if a party goes into possession of a property with an ambiguous property description and then pays rent, that the court will enforce it as to the premises, as relating to that particular premises. But here, that case is entirely an opposite, both because the property description is entirely clear and because Divine never paid a single cent in rent. So I think that is what the other side is relying on in terms of sort of obtaining rights to this property, and I don't think that stands. It's also the meaning of a lease. It depends on the party's expressed intent using an objective standard, and you only look at extrinsic evidence if it's relevant to show a meaning that the language is reasonably susceptible to. And the language, 1201 North Vine, is not defined by parcel number, is not reasonably susceptible to mean 1219 North Vine that has a different parcel number. In terms of St. John's status as plaintiff, St. John was acting as a master tenant for the lease of the land, but the owner of the improvements, the banquet hall, was only the diocese. And that is undisputed on this record. Oh, and then I also wanted to correct the record in terms of whether the diocese was getting any benefits from the 2009 lease. It was not. So the respondent's brief states that Divine was paying for the ground lease. It never did. So there was no benefit that the diocese got from the 2009 lease, and it did not ratify the lease. So unless you have further questions for me, I'm prepared to submit on the briefs and our argument.
I believe there are no further questions. Thank you. The matter is submitted and court is adjourned for the day. Thank you.
Thank you.
Thank you.